3171.
There's a show cause filed late last week based on continued drug usage by Ms. McGee despite her being in month 9 of her pregnancy. The court did issue that. I'm not sure if she's been served. And let's talk about it after appearances.
Lee Heiss, lawyer, guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Our workers are Christy Brinker and Ashley Beach on this matter, and Your Honor, I have not had contact with them. So I'm not sure if they were intending to log in. I am not sure. I haven't gotten an email that Ms. McGee was served. So
She was or was not?
I have no proof that she was.
Okay.
Michael McFarland representing Ms. McGee, Your Honor. She's not in the hall.
Thank you. She's nowhere. She on Zoom. Ms. Heiss, what are your thoughts on this? You just want us to move it out?
I'm going to need to check my court rules, whether we can progress. This is critically important, but I need just a minute. She hasn't been served. The agency hasn't been served. I'm fine to even delay a half hour and see if we can get everybody here and get her served. It's critically important.
I can stick around, Your Honor.
I agree with Ms. Heiss on this matter.
Okay, well, I can give you a recess on this case. We can get started on some of the other matters that are pending for this morning, and then you can let me know when you're ready to come back on the record. 171. Okay, good morning, everyone. This is, I'm sorry, I'm muting all of our participants that we're getting some noise from. There we go. All right, so the department filed a request to remove this child, the child concerned by this petition, which is the second petition. Well, it's a supplemental petition in this case for a new child that was born very recently, February 14th, 2024, asking for removal from mom. Mr. Stage also is putative father at this point. We did attempt to get Mr. Brooks to join us this morning, but I think there was some confusion about whether or not the hearing would be at 3 o'clock or 9 o'clock, which I do want to.
I did hear from Mr. Brooks' administrative assistant, and he should be available by Zoom in about 15 minutes.
Great. Okay, so he will be joining us approximately 15 minutes from now. At this point, Mr. Skyler Stage is the putative father. We don't have any indication that by way of affidavit of parentage, perhaps yet, I don't know. We'll give you a chance to talk to Mr. Brooks about that, Mr. Stage, but as of right now, you are not quite a participant in the sense that you are as it relates to the other child, because you have not been found to be the legal parent at this moment. So today's hearing is a hearing on the petition, the supplemental petition that also requests that removal. I have to decide whether or not to authorize the petition and whether or not the removal is appropriate. I have the names of our participants.
Lee Heiss, lawyer, guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Ms. Harvey.
Sarah Harvey, DHHS.
Michael McFarland representing Ms. McGee. Please introduce yourself.
Bonnie McGee, mother.
Thank you.
Okay, Mr. Stage, I did have to mute you on your end. If you would please unmute and give us your name for the record.
Skyler Stage.
Thank you. Welcome. All right. Looks like we also have some foster care caseworkers that have logged in from Fostering Solutions, as well as a supervisor from DHS and their foster parent. So welcome to all of you as well. Mr. McFarland, I understand you've had a chance to talk with your client.
I have. First of all, my client just given birth. I wanted to make sure that she was able to participate, that she was not under any medication. She had oxycodone yesterday for pain, but she just says those results are, she does not feel she's under the influence at this time, just Tylenol and other painkiller, Your Honor. But at this point in time, she does not wish to have the petition read. She has received it. I went over it with her. No Native American heritage on her part or possible father's part. With the possible criminal liability, the fetal endangerment, we would be looking for a no contest plea in this matter. As far as placement, she'd like her parents considered first. If they're found to be unacceptable, she has another child that, and we're not going to use the children's names, but she'd like this newborn placed with the other child that's in foster care. Yeah, I did go over her rights with her.
So is she contesting at this point the removal?
No, Your Honor.
All right, thank you for those pieces of information. That does answer nearly all, in fact, the questions under 3.965 governing our proceedings on a preliminary hearing. Deputy Ames, would you swear in Ms. Bobby McGee for us? Ms. McGee, do you have a copy of the petition that was filed yesterday?
Yes, I do. It's in my email, but yes, I do have it.
Good, and is everything that Mr. McFarland just shared with us accurate?
Yes, ma'am.
All right, thank you, very good. Any position on the request to enter no contest plea?
I have no position.
I have no objection.
Very good. Ms. Heiss, would you find it to be in the best interest of this child for me to receive the plea?
Yes, Your Honor.
Okay, well, Ms. McGee, then I'm going to go over your rights with you and as part of that process. If I accept your plea, you are giving up a right to a trial by judge or trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You would always have your attorney, you have a right to an attorney at each and every hearing as well, so Mr. McBrown would certainly be there to help you with all of those things at any trial. Do you understand you'd be giving up or waiving your trial rights that I've just went over if you enter a no contest plea?
Yes, ma'am.
All right, as it relates to a no contest plea, essentially what that means is without you saying anything, I will effectively assume that the allegations in the petition are correct and look at whether or not those violate the statute and require the court to intervene. Do you understand that?
Yes, ma'am.
All right. With regard to the consequences of that plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children or the child a temporary ward of the court, place with mother or father or with relatives or in a foster home, and order programs for you and your child, such as counseling, drug and alcohol treatment assessments, or parenting classes. If it appears you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, the plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. McGee?
Yes, ma'am.
Do you have any questions about any of the information I've given you so far?
No, ma'am.
Is anyone making you enter a no contest plea?
No, ma'am.
Has anyone threatened you in any way to get you to enter that no contest plea?
No, ma'am.
Do you feel that you are under the influence of anything that could get in the way of you understanding what you're doing right now, like any drugs that you might be on through the hospital or anything else?
No, ma'am.
Has anyone promised you anything in order to get you to enter a no contest plea?
No, ma'am.
Did you say that your decision to enter a no contest plea is one you've made of your own free will?
Yes, ma'am.
Very well. Ms. Thomas, at this point, look for you to establish the factual basis for the plea, please.
Thank you, Your Honor. If Ms. Harvey can be sworn in, please.
Before we get into that, I don't think we did this on the record. I know we discussed it just briefly by sidebar before we began, but the reason for the no contest plea, Mr. McFarland?
We did put this on the record. I said fetal neglect, Your Honor.
Okay.
Which would be a crime.
And that is based on?
The child or the mother testing positive multiple times, including just days ago, for controlled substances.
Thank you. All right. Very good. Go ahead.
Thank you. Ms. Harvey, can you please state your role in this matter?
I'm the CPS investigator.
Thank you. And as the investigator, were you able to establish that the child, I'm sorry, back up. As a CPS investigator, can you explain your process and how you formulated the allegations that are contained in the petition?
Yes. We received a referral that MS had been born, and that at the time of birth, mother did not test positive for any substances. However, there was an indication that she has had foster care and during that foster care case previously, she had tested positive. So I went over the testimony from the previous investigation and received a copy of the court report from the, from the foster care worker, which did show two positive tests for methamphetamine in the third trimester. The court results from MS are still pending. Currently, nurses indicate that there are no withdrawal symptoms, but we're still waiting for those results. They're trying to hurry those along as fast as they can. But we did have the 2 positive results on record.
And were you able to speak with Ms. McGee in this matter?
Yes, I did. I spoke with her yesterday.
Okay. And had she admitted to any use within the last?
Yes, she indicates that her last day of use of methamphetamines was January 28th.
And the current home that Ms. McGee is living in, is that appropriate for the child to be sent home to?
Fostering Solutions did the placement assessments on that home, and they indicated that due to safety concerns in the home, it was not appropriate.
And you mentioned that there's already another child in care that was born to these parents, correct?
That's correct.
And the reason that child was removed, do you recall the reason the child was removed?
I believe it was substance use and domestic violence and housing instability.
From review of the court report, were you able to determine whether the parents had complied with and benefited from their current case service plans?
I believe it indicated that there was a lack of compliance and minimal benefit at this time.
And were you able to speak with Mr. Stage in the last couple of days?
No, I have not been able to speak with him yet.
And to the best of your knowledge, he remains incarcerated?
Yes.
One of the questions that will likely be asked is the placement plan. The petition asks for the court to place the child with the department for parent supervision. Do you happen to know what the placement plan for this child would be if the court?
Yes, the current placement would be in the same licensed foster care home as the older child, SS.
And are you aware of any sibling visits that have already occurred?
Yes, there have been 2 sibling visits already that have occurred this week.
Is there anything else that you would like to state for the record to help the judge and make her findings?
No, just that it seems that the same issues that brought SS into care are still evident today.
As it relates to reasonable efforts, I know that there's a lot of citing back to the foster care case. Were you able to offer any additional services since your investigation?
Yes, we spoke about services. I kind of wanted to get a plan for her case service plan and how she felt about it and what she was looking forward to. And we did talk about the substance use, as that is my main concern in this case. I offered to assist her with the inpatient. She doesn't feel the inpatient substance use treatment is appropriate for her at this time. She's afraid that it will impact her employment, and she's only interested in outpatient right now.
Thank you. Your Honor, I have no further questions for Ms. Harvey regarding the factual basis of the plea. Questions?
I do. My understanding is that we do not have the umbilical cord results yet, correct?
That is correct.
We don't have any doctor's reports indicating that the child is born addicted or that there's any consequences of mother allegedly using controlled substances to the child, correct?
As of today, that's correct. They're still monitoring as the child and the mom have not been discharged yet.
Okay. So do you know the particulars as to why the home, I believe it's her parents' home, correct?
Yes.
Why that is not an acceptable place?
I don't know. I myself don't know the particulars on it. I didn't do the assessment. The fostering care, the Fostering Solutions foster care worker would have more details on the specifics for that.
So you're not going to be the ongoing worker, correct?
That's correct.
Because what happens if the results, the umbilical cord results turn out to be negative and there is no negative side effects to the child from my client's possible addiction?
Then we go back to look at the reasons that SS would be in care, which would be housing instability, and the domestic violence. Until very recently, there was no contact order, between the two parents that was continuing to be broken. So that would still indicate an issue there. And we still have the housing, with that, assessments have indicated it's not appropriate. While she is looking for housing, she has not gotten any yet.
Thank you. Nothing further.
Ms. Heist,
I have no questions. Thank you.
any redirect?
No, Your Honor.
All right, thank you for your testimony. May I return to your seat? Any other witnesses?
No, Your Honor. Your Honor, just as it relates to placement, if Ms. Ringer can you sworn in, please? Thank you. Good morning, Ms. Brinker.
Good morning.
Can you please state your role in this matter?
I am the foster care worker for the older child in care.
And will you be, if the court removes the child, will you be the foster care worker for this child as well?
I will, yes.
And it sounds like the plan currently is for this child to be placed with the older child in a licensed foster home?
Correct.
Okay. Can you briefly, I'm sorry, have you had the opportunity to explore potential relative placement for that older child?
Our agency did do relative searches, and all of the relatives that were given at the onset of the case have all been denied for various safety concerns, whether it be criminal history and or safety concerns in the home. All of the relatives have received a denial letter at this point with the opportunity of things that needed to be corrected. And we have not heard back for any reassessment from any of those relatives.
Does that include Ms. McGee's parents?
It does, yes.
And, okay. And so you have not reviewed that home recently, is that correct?
Correct.
Okay. Thank you. Your Honor, I have no further questions for Ms. Brinker.
So would you review Ms. McGee's mother's home to, and she would like you to do that?
Yes, I mean, if Mrs. McGee's mother would like us to come out and reassess her home, we would absolutely welcome that.
Okay, so the denial letter is from an earlier placement request, not for a placement request right now, correct?
Correct. I believe that they probably just received that within the last 30 days though. So they're aware, they were verbally told and then they received written list.
Because I don't have access to that denial letter. Can you tell me the particular criminality concerns?
I actually do not have that in front of me, and being there was other family members, I can't really speak to that at this time.
So we don't know that that house is not acceptable if we don't have that denial letter, right?
I just don't have the denial letter, the particulars in front of me because our licensing department handled that denial. I do know that there was still pending CPS charges from Texas that we were still waiting to obtain. I believe Miss McGee's mother was requested to obtain that, and we haven't received those.
Do you happen to know any of the physical barriers in the house just offhand?
I believe there was not suitable beds. And I honestly, I don't want to speak to it because I don't want to get them all confused. I believe one of the homes had a wood burning stove and there was no area for, the older child and to walk around as she was just learning to explore. I understand it's a little different for a newborn, but I believe there was not appropriate sleeping arrangements.
Okay, so it sounds like we'd have to do another inspection of the house then, correct?
We can absolutely do that, sure.
Okay, no more questions, Ronna.
Ms. Brinker, in your work with the older child, SS, we've had a psychological evaluation of this mother, isn't that right?
Correct, yes.
And her abuse scale was significantly elevated back in July, is that right?
Yes.
And do you think she has partaken in services and benefited from services to the extent that we can say that that abuse scale has been reduced?
She has not. She engaged initially and engaged with the McCullough and Vargas for about a month, and then discontinued services, and that is when she relapsed. She re-engaged right at the last court hearing. And then I actually just checked in with her counselor just to touch base again to make sure that we had the psych eval and that all the appropriate services were going to be in place so that we can get them reunified. And she states that she has not heard from Ms. McGee since February 5th. She knew that she had court that day and wasn't sure what was going to happen due to the show cause due to her positive drug screen. So that's 10 days that she did not have contact with her counselor or peer coach. So there are definite concerns about her ability to follow through with the outpatient treatment at this time.
Thank you. I have nothing further.
You redirect?
No, Your Honor.
One follow-up question, Your Honor. Do you think that your case service plan for this newborn child is going to be any different than the existing case service plan? For example, would you like a family team meeting to explore that?
I mean, we always welcome family team meetings.
Thank you. Nothing further.
All right. Anyone else you'd like us to hear from?
No, Your Honor.
Mr. McFarland?
As far as the paternity issue, on that issue only, I'd like to question my client, Your Honor, and the ICWA issue.
Go ahead.
Those
She
two.
has been sworn.
Bonnie, if you could unmute yourself. I know we had a discussion. I asked you, do you have any Native American heritage, Indian blood on your family or the possible father's family that you're aware of?
Nope.
Okay, and do you know who you believe the father to be?
Yes.
Who would that be?
Skylar Stage.
Is there any possibility it might be somebody else?
Nope.
And if you are approached with an affidavit, an acknowledgement of paternity, would you sign it indicating that he's the father? Or
Yes.
What's your position? Thank you. And I guess if I can just ask one question on placement, Your Honor. Thank you. Do you prefer your child to be placed, the newborn to be placed with your mother, or would you rather the newborn be placed with its other sibling right now for bonding? What are your thoughts?
Honestly, with her sister, like her to be placed with her sister.
Thank you. Then I withdraw any concerns I have with family placement, Your Honor. Nothing further.
Did you have any questions for this witness, Ms. Thomas?
We do not, thank you.
Ms. Heiss?
I have no question. One quick question. You are bottle feeding this child formula, is that correct?
Correct.
Thank you. I have nothing further.
You look like you might have another question.
Well, maybe another witness. I'd like to call Ms. Brinker regarding parenting time. I think she'd be the person that'd be appropriate to ask that.
Very good. Go ahead. She is also under oath.
Ms. Brinker, with a newborn child like this, you would agree that the mother-child bond is especially important, correct?
Yes.
What would you propose or suggest for parenting time for my client and the newborn?
Well, the minimum is 3 times a week. I do believe we have that already set up with the older child at this point, with the supervised visitation and then 2 additional visits. Also, I am a little, I'm concerned about Miss McGee, and I think that the removal could potentially be another trigger for her. So I'm absolutely willing to go above and beyond on this and get her visitation as much as we can possibly schedule.
So if she demonstrates a history of sobriety from drugs, I presume you'd be testing her, correct?
Yes.
Would you consider expanding that if there's no safety concerns then?
Absolutely.
Nothing further.
Any more questions for any other witnesses?
No, Your Honor.
Comments?
No, Your Honor.
Mr. McFarland?
No, Your Honor.
Ms. Heiss?
No comments. Thank you.
All right. Well, the court finds all parties were given notice for purposes of today's preliminary hearing and request for removal. I do find that at this time, with the issues with where Ms. Bonnie McGee is staying, that the safest and least restrictive placement for this new child is, in fact, under the discretion of the Department of Health and Human Services, which I believe is also, the plan is to place this child with the sibling. Obviously, there are benefits to that. This is a situation where mom's housing is not appropriate for the child. She also has some services that she needs to continue. She needs to follow those recommendations to address the things that were raised in the psychological evaluation. She needs to do some parenting education around how those issues could affect her ability to parent a child safely. I do want to recognize, and I don't know that we have any drug test results right now, but I do want to say that I did ask Ms. McGee to stop using methamphetamine as soon as possible under threat of incarceration, but I know that it's a difficult thing to struggle with addiction. And I just want to say that I'm glad to see that she was able to refrain from using at least from January 26th until the child was born, and that the child is not showing any signs of withdrawal. So I know this is a difficult hearing, and I am removing this child, but I want to take a moment to recognize that Ms. McGee was able to at least make that progress since January 26th. So congratulations to you on that. That will certainly influence the court moving forward as far as what kind of parenting time. I would encourage the department to have a family team meeting on that and set up as much frequent parenting time as could be organized between this mother and child. But I do find, as it relates to the petition, that there is a violation of the statute as it relates to provision specifically around the care and maintenance of the child, the necessary medical and care necessary for the child's health, in that the use of methamphetamine during the pregnancy has subjected the child to a substantial risk of harm to the physical health of the child. I also find that the housing and the unremedied issues that were visited on the record contribute to support of the violation of that provision by probable cause. And secondly, if those same facts and circumstances support that there's been a violation of the statute MCL 712A.2b, I think this is for around the home or environment of the child, if I were to place with mom. The putative father is, of course, Mr. Schuyler Stage. And our next hearing, which would be the disposition, I will also set a putative father hearing. Mr. Brooks has joined us by Zoom, so I'll make some time after this for him to talk with his client about steps to be taken on that point. But we'll look at that issue when we come back for disposition. As it relates to removal, okay, so yes, the plea, back to that for a moment, sort of jumping around, I apologize. The plea was knowingly, understandably, and voluntarily made with full understanding of the consequences. I have already found that the record supports that 2 of the pieces of the statute that are applicable have been violated, so jurisdiction over this parent is appropriate, and I am accepting her plea and will take jurisdiction over her for purposes of looking at whether or not she was able to make more progress on her case services plan between now and when we come back, in the name of reunification with her and her child. In the meantime, I am ordering the placement of the child into foster care under the supervision, obviously, of the Department of Health and Human Services through the agency Fostering Solutions, and specifically Ms. Christy Brinker at the moment. For the same reasons that the court took jurisdiction over Ms. McGee, I find that custody of the child with this parent does present a substantial risk of harm to the child's life, physical health, and mental well-being. Find further, for the same reasons, that no provision of service or other arrangement except removal is reasonably available to adequately safeguard the child from risks as described above, or before, I should say, that also support 2A. And just for the record, I'm under MCR 3.965C2. On 2C, continuing the child's residence in the home is contrary to the child's welfare for the same reasons. And D, I do find that reasonable efforts were made to prevent or eliminate the need for removal. And those were also explored on record through our caseworker. E, conditions of child custody away from the parent are adequate to safeguard the child's health and welfare. The child will be joining its sibling in a safe home where she will be able to visit as well as visit with parents. We've already visited the contrary to the welfare of the child factors and the reasonable efforts factors. All right, for purposes of initial disposition and the putative father hearing, let's see. We just had a regular review on this case. Review is not scheduled until April 9th, 2024. So rather than waiting that long to look at the disposition on the the supplemental petition, I could offer you some time in front of the referee, if you like, for the initial disposition and putative father hearing.
No objection.
No objection.
Yeah, no objection.
All right. That would allow me to set that then for somewhere in the week of February 26th through March 1st. Wednesday, the afternoon of the 28th at 1:30. And that will be for the, again, for the putative father hearing, as well as the initial disposition on supplemental petition. And then, of course, after that, and we'll communicate this with the referee, the regular review should be scheduled with the already previously scheduled regular review. Any questions?
No.
Okay. Thank you very much, everyone, for joining us. It's such a